Grant Harpold is the HAR Legal Counsel and is always there to assist HAR and its members with all things legal. And keep in mind, if any of us stare at the camera for a little bit too long, it's because this is live and it's really, really fun. And if anyone does it, it'll probably be me. So apologies ahead of time. Anywho, if you've met Grant, you love him. He's going to talk about all things legal. We don't want to get in trouble, right? We just want to get out there and sell some houses and run some brokerages. So he's going to chat about COVID-19, fair housing, current legal topics, you name it. Grant, it's all yours. Throw in the baton.
All right, thank you, Katie. Exciting to be on during the lunch hour. So here we go. Let me kind of share my screen here and get going. I think I got it there. Yeah, share should be good. So virtual engage, VE. This does not mean Victory Europe for you historians out there. This means virtual engage. And so we got a few topics: procedure, practice, and policy. And kind of the first subject on procedure is fair housing. And let me just say on fair housing, apparently, for some that has been reported in the past, this can be a difficult issue. For others, it's not, but it's something I think we need to cover and address. And I look at fair housing kind of like you would, it's kind of how you conduct yourself in your personal life. It should transfer over in your business life. And in your personal life, I think we strive to be fair and honest and forgiving and sensitive. And so that should apply to in our business world, especially for realtors. And so that's kind of the concept of fair housing. I mean, if you look at, and I've kind of outlined some terms here under the fair housing, it's, and I'm looking over here at the screen also, it's equal professional service to everyone. I mean, that should be fundamental, basic. And I think everybody tries to do that, and some maybe fall a little short, but nobody's perfect, but I think that should be something we strive for, not only in our personal life, but more importantly, in our business life as far as treating others. Part of that business is advertising. And so when you advertise with the consciousness of fair housing, it needs to be inclusive of everyone. It means open to everyone, not selective and not exclusive, leaving somebody out. And you should, in the business world, in your world, and like I said, I think it applies in your personal world, and I would take that on myself too, is refuse to tolerate non-compliance. Refuse to tolerate people not being fair or not being all-inclusive. So I think that's important to remember. Celebrate our differences. That's a great thing, especially here in Houston. Wow, celebrate that. I think it's great. It's fabulous. Be positive. This is not, this is not something that is a bummer, so to speak, that we have to be fair to people. Be positive. Be take that as something good, something positive. And in our communities, in our city, wherever we are, let's not categorize communities or think of somebody should be here and somebody should be there, and I'm not going here with this person, I'm not going there with that person. That should not be our thinking. Get on the road and go wherever one needs to go. And so when you think of fair housing, it's can be an Article 10 violation. So you actually could have an ethics violation brought against you by anyone. And so that's something to think about. It's Article 10, and there we are. I have highlighted what we need to be thinking about and they being all inclusive. And when I say familial status, you see that there, that people forget that includes families and children. So that's something else to be sensitive to as you take this walk. And so I'm trying to get back to my screen. There we go. So this is important stuff. And so just kind of a subset of that is COVID-19. There is no waiver under fair housing just because we're in a virus or pandemic situation. So it still applies. Don't now fall back into what we sometimes do is we place a stigma on people because of their national origin or in relation to the virus. I mean, that's now not being fair, as being simple as possible. Keep it fair. treat somebody who may have the virus or had the virus as being covered by fair housing. That's the simple way to do it. It's okay to inquire about somebody's past exposure or symptoms. That's been pronounced by the government on as far as the virus goes. And like I said earlier, the family status, children, you can't somehow use the virus as a means of not being fair to those who seek housing that have children. And you know, the way to handle this, especially with respect to the children issue, if you're showing a property and you don't want to be accused of being not fair, is to restrict the number of people on the property at one time. It's okay to not have to show a property to be threatened for your health and welfare. So you don't have to take a risk health-wise to show a property. You can provide a reasonable accommodation to that. The government's clear on that. Virtual tour or have somebody act on behalf of the person who may have an issue or may provide a risk to you. And at the end of the day, if you're not sure what to do, go back to the CDC rules, even though those are constantly changing. And that's, to be fair to everyone, this is sort of a moving target in this environment that we're in, specifically with respect to the virus. So that's kind of it's kind of fair housing. I saw in the Wall Street Journal today that Uncle Ben's is changing their rice name to Ben's Original, and so I let me show you this. If you can see it, there's an article. I don't know whether you can see it or not, but there's an article saying that Uncle Ben's, full-page ad, Uncle Ben's changing to Ben's Original. We've listened, we've learned, we're changing. That's good stuff. That's good stuff. At the end of it, they said, the very last part of the ad they put in the Wall Street Journal, they said, we work to ensure everyone is always welcome. Everyone is always welcome. God, we should live that way. I mean, that should be our daily life. We should transfer that also to how we conduct ourselves in the business sense. So let's now go to more practice. That's the second key of what we're going to do today. So this is more now, you know, the previous fair housing was something that you should incorporate. Now this is more sort of the practice, and specifically with respect to the disclosure statement. Buyer's agent, seller disclosure notice. And I have something to show you on that. Let me pull that up. So imagine this. This is real life. This is true. This is a case, and I put up there. Let me see. Let me make sure I got it up there. So I put it up there. This is a seller's disclosure notice that real life, real case. And look what happened. Seller disclosure notice indicated yes to previous flooding into structures, but did not provide the required explanation. The disclosure indicated a no answer to previous flooding on the property and water penetration. So it said there was previous flooding in the structure, but no about previous flooding onto the property. So I think you might realize this, but for you that don't, there's a conflict here. There's one you can't have flooding into the structure, not onto the property. And so when one reads that, that ought to raise a red flag immediately. Then if you go on to, in this same disclosure statement that was in this case, it's a matter that became a lawsuit. They left blank improper drainage, present flood insurance, located on a 100-year floodplain, they left all that blank. And so what happened here? Well, what happened here is that the buyer's agent got in trouble. I mean, I could probably talk about the listing agent's mistakes in this thing too, but I'm really focusing on the buyer's agent. But as a side note, listing agent should always make sure that the seller disclosure statement is completed by his client. That's fundamental. But here, this seems to be an issue that I've seen more often, is that the buyer's agent doesn't seem to think they have a responsibility. And so when their client gets a disclosure statement that is incomplete or perhaps has a conflict, then it's a duty, a legal duty on the buyer's agent to alert its client about the improprieties in the seller's disclosure notice. So let me go back to my thing here, and I got a little laid it out a little more. So the buyer's agent can be held responsible for the missing content. You would say, well, wait a second, wasn't that the listing agent's responsibility? Well, you're going to get shared. You as a buyer's agent may have some shared responsibility if you allow your client to purchase a property with an incomplete seller disclosure notice. You think, Grant, come on, that's basic. Well, I know it's basic, but I see it happening. And like I said, to the point of litigation, buyer's agent may be responsible for conflicting content. So if there's a conflicting content in the seller disclosure notice on behalf of your client, you need to ask questions. That was a little bit out of order, but if you see that, you need to ask questions. You need to get answers. And when you get those answers, especially if they're material items like flooding, flooding, you should get those answers in writing or confirm them in writing. I mean, maybe it was verbally said to you to the extent the flooding was, or maybe the disclosure statement is completely filled out, but it requires more questions to fully understand what's going on here. You need to, if something verbal is said to you, I think the best practice from the buyer's agent is to confirm that in writing. If the listing agent won't give it to you in writing in some manner, then if it's verbally given to you, then you confirm, you told me that the water only came in to the front porch, or the water only came to the back door, or the water came into the kitchen, or the water didn't come in at all, it just sat in the front yard. Whatever it might be, that's critical information. And if it's verbally exchanged, that's trouble. That's trouble down the road if there's ever a dispute. So you need to get it in writing, or if you can't get it in writing, you confirm it, buyer's agent, back to the source by email. And something else on this, of course, always review. We know that. I said that, but there it is again. Always review the seller disclosure notice. Not only because, let's think about it. A lot of times your buyer, and in the case I'm talking about, the buyer was not very sophisticated, first-time home buyer. So they don't know, they're getting hit with all this information, and especially nowadays with the length of the seller disclosure notice. And so they may not be able to comprehend it. You, as the buyer's agent, can comprehend it. Sorry, that's on you to be able to comprehend what's going on here. Or if you can't comprehend, then ask questions. And so I think it's critical for you to be front and center on reviewing the seller disclosure notice to help your buyer better understand it, and to help your buyer get better or more thorough or further information. And then also back up here, right there at the earnest money termination in paragraph 7, it could be argued. Let's just think about this. And then there actually was a case on this some years ago. It can be argued that maybe that provision in the contract, paragraph 7, about receiving the about receiving the seller disclosure notice, if it's incomplete, especially incomplete with material information that's required by law to be provided by the seller, then, and you provide a seller disclosure notice as the listing agent that's incomplete, then the buyer might have the opportunity to, down the road, or without timely getting the seller disclosure notice, to terminate the contract. And so that's not going to look very good to anyone if that were to occur. So keep that in mind as you navigate through the process of the seller disclosure notice. It's the starting point of this whole process, of the information gathering process, of the knowledge gaining process, is a seller disclosure notice, and even more so. And so the buyer's agent has a role, a big time role, in making sure that the information is thorough, is there, is complete, and that the client understands what's going on. And that's why you're in the transaction. That's why you're relevant to the transaction, is to assist in that process. So I think that's all I had on buyers. seller disclosure notice. I think I'm doing okay on time, so let me keep going here. I think people are watching. I hope people are watching. So back to, so public marketing coming soon. Still some issues on this, and probably still some educational process on this issue. And so, you know, if you have a property that's not in the MLS and you've gone office exclusive, but then you decide to public market it, and I'm kind of giving an example here: yard signs, email, social media, websites, anything to the public, then that property needs to be submitted to the MLS within 1 business day of you making that public marketing move. Are you doing something, like I've given an example here, that transforms that property to something more than an office exclusive? So as I said, you need to submit it to the MLS within 1 business day of doing anything public marketing of the property. Office exclusive means what it says, and there's probably still somewhat of a debate, but office exclusive means that it's not on the MLS. It's being maintained within the office itself, being shared with other agents within the office, perhaps clients of agents within the office, but that's the extent of it. If you start going beyond the office, if you start doing public marketing, then it needs to get on the MLS, and it needs to get on there within 1 business day. So I think there's still a few hiccups in understanding that process, or remembering, probably more so, that process exists. But so that's kind of a good overview of what to remember. And if you're going to do an office exclusive, remember the form, HAR 300 form, which shows, you know, that's giving the seller all the information about the fact that it's excluding it from the MLS. And it's, you know, it's for the seller's benefit, it's for your benefit to have that form and to have it in place if you're excluding the listing from the MLS. Coming soon. Coming soon is advertising, okay? So if you think that coming soon is pre-MLS in the sense that you put a sign in the yard and you think I'm okay to do that, it's pre-MLS, well, yes, it's okay for 1 business day, and then you need to get it in MLS. So you can, if you do coming soon and you put it in MLS, you can have a sign in the yard, that's okay. If you do coming soon and you don't put it in MLS, but you put a sign in the yard, you need to now, it's triggered the public marketing that we just talked about. And so the property needs to get into the MLS within 1 business day of putting that sign in the yard. Remember that on coming soon, there are no showings. So that's something that you need to remember. And remember also on coming soon, it doesn't get sent out to any portals, and it's not on har.com. So it's, you know, it's limited in its purpose, and probably for good reason. I don't see anything else that I need to go over with y'all. This is those are kind of the three topics I could jam in 20 minutes, and I think I've done it. Hey, kudos, I've done it.